some folks are here, some folks are not. We're not going to rehash and relitigate necessarily, but Susan Cohen with the Restaurant Association, Hospitality Association, come on up if you will. And well, you know this well, and we know each other well. If you will, raise your right hand. You swear affirm to tell the truth, the whole truth, and nothing but the truth. You sat through every subcommittee meeting that has taken place on the Senate side, not only this year, last year, in addition to every subcommittee meeting that the House has conducted. Fair? And so my question to you is to, is that green light on up there?
Yes.
Okay, good. Pull it a little.
Do I need to lean up?
Yeah, there you go. My apologies. In terms of your liquor liability umbrella, tell us, does 184 or does 244 affect the change that you're looking for, and at what cost?
I think I would echo what a lot of people have said, is that we don't have any guarantees, because there are some folks that we haven't really heard that from. I will allude back to, I know Alabama has been discussed a few times and what they have done. They have seen some carriers come back. It's been slow. I think they're in year 2 right now. They have a much, much smaller mandated coverage. I think it's $100,000. I believe you said that you think a mix of the two dramshop pieces of both these bills probably is a better look if you're just looking at the liquor liability. I think from our perspective, we are looking for anything substantial enough to make a difference. We just don't know that we have the answer of what will make the most difference and bring it, close any loopholes that might be there. We know that we are already pushing very, very heavily the training, despite what others might have you believe. It's one of our biggest initiatives. We know that the insurance carriers are weighing the hours. They're also weighing that alcohol to food percentage, which can get iffy there, because you can serve some very premium alcohols that a very small amount could be more expensive than a meal. So there are a lot of variables. We are very encouraged, as you said, by what we heard and people working together on language. But I don't know that anybody feels at this point whether we have an assurance that we're going to see a wholesale change.
Right, and again, y'all don't, it's not my conversation, y'all pipe in at any moment. I do want to ask, and then I'm going to turn it over to Senator Ott, the perception that some in your industry would have that there is no market for insurance if you've had no claim, if you've had, you've been a good operator, you have managed and watched the owners, the managers, whoever's tasked to protect that license that your members have,
Right.
which is a license to guard against a very dangerous commodity, which is alcohol, that we know the overconsumption of which leads to injury and or death of South Carolinians.
Sure.
If you're a good operator and you're not pushing the drinks or the server who might not have the interest of your member at heart, but has more of an interest in getting a bigger tip, to push and allow someone already intoxicated to have more, is there a sense that there should be a carve-out or some recognition either imposed by our state or the Department of Insurance or Department of Revenue that does not reward the bad actors at the cost of the good?
Yeah, I mean, I don't think anybody can deny that no matter what your industry is, there are bad actors, and they give all of us a bad name, no matter. And we have no problem with holding the bad actors accountable. I think where it really hits home with us about what is making the difference with the insurance carriers is when we have members who will reach out to us and say, hey, look, I'm not even open past 2 o'clock in the afternoon. I don't even have to carry the mandated $1 million, and my insurance carrier just dropped me and would not write me because of what they called our one drink rule. So that gets a little bit more back into 244 and not so much just a straight dram shop. I will say again, we will push the training. We already do. I can't imagine any good operator allowing a server to be pushing drinks. I think the amount of tips you would get from that are probably not worth the risk. So I'm not saying that doesn't happen. I'm sure it happens, but that is not an industry-wide issue, and it has felt like our industry has been painted with a very, very broad brush related to that.
Kind of like bad actors, perhaps, in other professions that become the norm.
Yep.
Perhaps. So, Senator Wright, you want to chime in on that, or I was going to ask one more question, and then I'll turn it over to a couple of others that have asked to be recognized. But there was a regulation issued in 2003 from DOR interpreting that liquor liability minimum limits policy involving one occurrence or more than one occurrence. Are you familiar with that concept at all?
You're predating my knowledge. I apologize.
All right, in 2023?
About what?
I'm sorry.
You said 2003.
23,
Okay.
2 years ago, that DOR issued guidance interpreting the liquor liability to provide for an aggregate, not a per occurrence.
Right. We asked them for their interpretation of the $1 million, and that was the response that we got back, that it was aggregate and not per occurrence.
Right, and that was from on high. Both the Department of Revenue and Department of Insurance have indicated that that was their interpretation, correct?
That's what we were told.
Okay. So the hope there was, and the sense was, that that was going to either stave off the insurance premium increase and hopefully avert what you are saying exists to this day.
Yeah, I think that would have been nice to see that help. That's why I have hesitancy in relying on just addressing that $1 million. I think that when we do have an insurance entity who will talk with us, they will say that they are just concerned about someone going to trial and being held accountable for things that was not equal to their amount of responsibility in an accident. And so I've heard, and I've said it in front of both of these groups in the past, I mean, it's really disheartening to hear someone say somebody's got to pay, and my response is the guilty party has got to pay. And that's, I think, where we are now, is that some of our very good operators, because they have really good insurance and they try to go and stand up for themselves in some cases, then or either their insurance carrier just says, hey, you need to settle this. And so they have to come out of pocket, and they really weren't the ones responsible. So that's why we continue to say we are happy to help support stopping the bad actors. We think maybe another step that wasn't really discussed in any detail in some of these hearings was, where does the operator, the server, I shouldn't say server, the owner's responsibility end? Because we have cases where a person left, they were stopped from getting in their car, they took an Uber home, and when they got home, they got in another vehicle. So we can't do anything after they get home. We don't know what they have access to. One of them was even a golf cart. I mean, so some of those parameters have got to be in place to protect those who really, truly did not overserve or contribute in any major, at least not to the 50% of that responsibility for that accident.
Senator Rock.
Thank you, Mr. Chairman. Susan, thank you. I appreciate you speaking to, the fact that you don't know if these changes will immediately or how long it will take to drive premiums down, or if they will at all. But I was just wondering if you could speak to what is actually happening right now with the law as it currently exists and the impact that it's having on the members of your industry and what they're ultimately dealing with.
Right. Well, I mean, you've heard the people you've heard testify in these sessions are, in fact, very good operators for the most part, who have just seen their premiums skyrocket. But more so than that, they have seen, and I think Carl Sobocinski might be one who testified that his broker sent it out to like 40 different entities and maybe got quotes back from 3. And how we are covered with umbrella policies has basically gone away. So now it's not just affecting my restaurant members, it's affecting my hotel members who used to get the umbrella policies, and they're now seeing alcohol backed out. We hear a lot of people say, you're giving us anecdotal, and we've heard people say, well, Perry came and he testified. He said, y'all aren't closing. We are closing. That's not to say that somebody new is not stepping in and that somebody new is not getting an alcohol permit, but they don't have some of the same challenges. But again, Steve Cook stood right here and talked about, or someone alluded to his situation right now. He's trying to open a new restaurant in Lexington, and he has a great track record, and he can't find his coverage for that new steakhouse. So it's not anecdotal. You've probably all of you seen VFW posts and others in your areas who have lost their ability. Golf courses. I mean, guys, I used to help promote golf industry in Myrtle Beach. I don't think I want to tell too many golfers that we can't send that beer cart around and serve them drinks. And they certainly can't cut it off at 5 o'clock because it stays daylight a lot longer than that on the golf course. So we are where we are.
And good afternoon to you, Ms. Cohen. Good to see you again. I think you and I first met several months ago before I got sworn in, and in fact, we had a conversation about this issue. So I know where your heart is. I know your intentions are pure, and you want what's best. A lot of the rhetoric, a lot of the chatter, I should say, around this issue, joint and several. The assumption is that joint and several is the norm. It is the standard. When in fact, in South Carolina, joint and several is the exception. And it's only triggered when you have the use or the sale of alcohol, use in illegal transfer of drugs, or gross negligence, recklessness, and so on, subsection F. But in most cases, defendants are held accountable for their pro rata share. Here's what I would ask you. If S-184 passed, which deals with dramshop and codifying what the common law says around around dramshop liability, and if we were to not eliminate joint and several, because right now S-284 proposes to eliminate joint and several in its entirety, rather than eliminate it, we actually were to remove the language that creates joint and several in instances of the sale of alcohol. If we were to remove that language, would that provide the necessary solace for your members?
I don't know that I can give you that definitive answer. I would say maybe I take it, I read it, and I do not have a law degree, and I might read it a little bit different. When you're talking about joint and several, about any other industry, it's you have to be 50% responsible. In the case of alcohol.
Correct.
Right.
You're right about that.
And I'll be honest with you, another thing that, I have not tried to muddy the water. I mean, we have a lot of industries in this state that are hurting right now over the same issue. So I can only speak to what I hear from my members about alcohol. And, just as I mentioned, the situation where a patron had been put in a car, got home safely, then left again. And that's something we cannot possibly foresee or control. By the same token, I have asked for and not been able to get any kind of clarification on, of the DUI cases, are they just alcohol? How many of them are just drugs? How many of them are both? And if there were both, when were the drugs ingested? Because alcohol is at least a legal but regulated product. Drugs are illegal. So there's so many nuances that I think could ultimately affect our industry. But I will say again, we've got to do something sooner than later that is significant enough to at least begin moving that needle.
But your industry, Ms. Cohen, I'm assuming is majority restaurants and bars, right?
Mostly restaurant.
Mostly restaurants. And these are restaurants that are engaged in the sale of alcohol, right? So if we were to eliminate, that part of subsection F, which relates to the sale of alcohol, which then creates that exception that we're talking about, and triggers joint and several. If that language were eliminated, you don't believe that would help, or that would bring some solace to your members?
I think we would like to think it would move the needle, but I don't have any assurances of that yet.
Okay, all right.
Thank you, Mr. Chair, and thank you for being here. And the questions that were asked, and I understand your position is that, and that's the same thing I struggle with, and I hate that you don't have the answer to that, because the people who can give that answer have not been a part of this conversation. And so my question to you is, you mentioned earlier when they do talk to you, i.e. the insurance companies, which I assume is very not often, has there been any conversation because we talk about fairness, and yes, perhaps it's a general consensus that we know businesses are struggling, but when we talk about fairness, has there ever been any consideration or talks about within the industry differentiating the 82 queens, the people, the restaurants who have almost never had any lawsuit filed because they are the good actors, versus the bar and maybe 5 Points that have had continuous violations in the sense where, and auto insurance.
They do that. Absolutely.
So they don't charge the same premiums for, because what I've been hearing is that the good actors, their premiums are skyrocketing just the same as the bad actors.
No,
is that not true?
Oh, everybody's skyrocketing, but in different increments, definitely. And I would say that the bad actors are finding it more and more difficult to just get it, period. At least the good actors can get it. It's just becomes so expensive, it's a moot point. People kind of assume that the restaurant industry is very lucrative, but statistics show that on the across the board, for the most part, they make like single-digit profit margins. So when you start whittling out hundreds of thousands of dollars, and that is what we're hearing of increases, then and it's just supply and demand. If you've only got 2 or 3 people that are going to write, then they know that competitiveness is kind of out the window at that point. They're just like, here's what I have to offer, take it or leave it. And you either take it or close your doors or stop serving alcohol. And
doesn't it seem unfair to raise the premiums of the restaurants or businesses that have never had a violation? Maybe not on the same level, since you said they are differentiated, but would that not be unfair to continue to raise theirs when they have not done anything or cost the industry any money, per se?
Again, just as unfair as making a good operator pay
Right, well, and I get that. And so there's what
yeah.
I'm getting at is it seems like there's a lot of unfairness going around. We're talking about only one thing that seems to be unfair, but and even with like auto insurance, I mean, I don't know how are there any incentives? Auto insurance, some companies now, and there's not a lack of auto carriers, but I mean, you have companies that there's an app, and if you don't speed, I mean, if you don't
Right.
get some, they reduce. That's an insurance.
Right.
Your premium will reduce if you do this. We don't have that
Right.
in your industry, and so I'm asking
Yeah,
why is that?
We actually do have that. And
Okay,
so when we have educational events and we do webinars about various things that are affecting our industry, for example, you would have, anything that would help decrease your risk. It could be alcohol, it could be any number of things. Or we have, just what are your operating practices? What are your training practices? So the people, you ask those that do talk to us, they tell us, they look at what time you close.
Okay.
They look at the alcohol to food ratio. They look at training. And again, I mean, to be brutally honest, we push training of alcohol and food, safe food service more than probably any other program we do. It's a necessity because we help our operators who are still looking for qualified employees get them in and get them up to speed as quickly as possible. And so
No, good. Well, and so to that point, since that is a conversation, so do you all, have you seen where those restaurants who may close earlier, I mean, do they have lower, I don't know, so I'm asking. 'Cause I
yeah,
heard you mention the 2
again,
o'clock.
their premiums are definitely lower than the bad actors that we're calling it, or someone who stays open later.
But there's still.
Or maybe
there's
someone in a
sort of-
college town that is primarily, more of a bar. I think that operators right now are doing everything they can to try to decrease their exposure.
And have they seen a decrease? And that's what I'm saying.
And again, I go back to supply and demand.
Right.
You went from 40 or more, and I'm not throwing shade at the Department of Insurance either, but the statistics that you guys heard were from 2022. And we definitely had a problem then. But 23 and 24, I mean, it just went down the drain, if comparatively. So again, what I look at is primarily the loss of competitiveness because there's just nobody to quote them.
Gotcha. Thank you.
Thank you, Mr. Chairman. Thank you for being here. I wanted to just respond to the back and forth, the conversation you had with Senator Walker, because I'm confident that eliminating subsection F does not address the problem. In fact, I think subsection F rarely comes into play. The issue is well, first off, joint and several is a problem for your industry. It's a problem for multiple industries. It's not limited to alcohol sales. But this gets to the real reason that we're here. Smith versus Tiffany, which was decided by the Supreme Court in 2017, really addressed what that section means above when it references defendant, right? So it doesn't, when it says that a defendant is can be responsible for the entire verdict only if the defendant has more than 50% of the responsibility, well, that hardly ever comes into play because in the situation that we just heard about, if a bar serves and then does the responsible thing, notices that the person is intoxicated, doesn't serve anymore, actually calls an Uber, gets them home, right? Well, let's say he's been to other places drinking, but later on, several hours later, whenever, gets in the car, he drives, he hurts somebody. If that bar is the only defendant, that bar is going to be 100% responsible for the damage. Because the way that is written, it's limited only to defendants. It does not include other parties. It doesn't reference other people who have contributed to the harm. Eliminating subsection F doesn't address the problem. The problem is the underlying law that allows for the very thing that we've just heard about, and that is you could be responsible for harm that somebody else causes. Subsection F doesn't address that. It's the underlying law. The underlying law has to change in order to address that, because right now what's happening is the insurers are including that in their risk assessments, that you could be on the hook for things that you didn't cause. And that is certainly contributing to the increased rates that we have. In order to get at this problem, this is much bigger than subsection F. This is the whole joint and several law, right? And unless we address the whole thing, not just for the alcohol industry, but also for every other industry, if we don't address the whole thing, we're not solving the problem.
And thank you, ma'am. Thank you for being here. Let's go back to, I want to talk, we're bouncing back and forth on 184 and 244, and there's elements of liquor liability, dram shop in both. But let's talk generally about the good actors having the rates rise, because I know, Senator Charleston, you mentioned that a moment ago. I mean, anybody that deals with insurance, and all of us have different types of business, and we've seen this in every type of business. Even good actors will experience a rate increase if there's market pressure, right? That just happens. That's the nature of insurance. I mean, it's essentially a shared risk pool. So I've seen that happen in other industries where if there's extraneous events in a market, even if you're a good actor, you may not experience the rate shock that others do, but you're going to see it increase. And that's what you're speaking to, right? Essentially, yeah, you may not have a 300% increase because you're not behaving badly, but you may have a 150% increase even if you're behaving well.
Right.
Because essentially, whenever you have enormous losses, that gets spread across premium, and that's what's happening. So you've got to find a way to limit that. Let's just, I'm going to talk about the language in 184 because we're going to talk about both these bills coming out here today. So I know there's the broader conversation on joint and several that affects more than just liquor liability, right? But if we go into Senate Bill 184 in Section 15.3-710, if you amend this section of code, right, it's essentially setting in some parameters as to what a licensee would do. So if you're basically now saying at the time of the sale, service, or furnishing of alcohol, you would have to know or should have known that this person's intoxicated. So now you're setting parameters there. You talk about the example you gave earlier, okay, because I think that's what's happened. I know people in my district that have experienced exactly what you described. There was a bar owner that I know personally who was very responsible, had never had any claims before, served a guy a beer, realized pretty quickly this person had already been somewhere before, and cut him off. Said, "You're not getting anything else." He pitched a fit, showed out, he made him leave. Went next door to the liquor store, bought a fifth, drank it in his car, and then killed a family. And then he got sued for that. Okay, he had the deepest pockets, got into some trouble over it. It really hurt him. He didn't do anything wrong. Okay, he cut him off. He did what he should have done. But if you take the language in Senate 184, he wouldn't be in trouble there because he knew this guy was behaving badly. He said, again, at the time of the sale, service, or furnishing of the alcohol, the licensee knew or should have known the individual become intoxicated based on factors that would have been obvious to the reasonable person. Well, it was obvious to him. He cut him off. So to your notion earlier, he leaves, goes somewhere else, which he did. This guy wouldn't have been liable. Do you agree?
You would hope.
So in your conversations with insurance companies, I mean, and look, I'm not beating up on insurance. I wish they'd talk to me too. But when you've talked to them, do they seem to think that would solve the problem?
You're really putting me on the spot, putting words in other people's
mouths.
mouths.
I'm not trying to make you do that.
Yeah.
I mean, it's really hard, and I'm not trying to be a smart aleck and say
No,
it.
I
just wish that it would be really great to solve a problem if we could talk to folks that need the problem solved.
Right. I think what you're describing is just what we hear over and over. And there are people who say, well, that's not really what's happening in real life, but it is, because we get enough phone calls at our office to know that it is happening. And it's not the ones that are always hitting the news. I mean, the ones that are closing, that is hitting the news. But, it's just really hard to 100% monitor an individual's behavior. I can tell you of a venue right now that does concerts, big venue, who said, I walk through our venue after a show. And they have to carry the million because they serve, their nighttime shows. He said the number of mini bottles and small flasks that can be put down in somebody's pocket or boot is mind-boggling. But if they left here and they had an accident and they asked them if I sold them alcohol, if I sold them a drink, then I'm screwed. Sorry, that's probably not a cool thing
We've
to say.
said worse in this building.
Yeah, believe me, I have too in this one. But
I guess what I'm getting at is,
truth hurts.
look, I'm not a lawyer by trade either. So somebody can correct me if I'm wrong here, but the evidentiary standard in a civil case is preponderance of the evidence, right? So you'd essentially have to, by preponderance of the evidence, under this kind of language we're talking about here, prove that this restaurant owner knew that this person was intoxicated, knowingly made them intoxicated or made it worse, and then you're going to hold them liable at that point. I think that goes a long ways toward helping reduce the problem. I'm not saying it's the panacea that fixes everything. I'm just saying it helps. And I'm not saying that's necessarily the end of the conversation. I think there's a broader conversation to be had. But there's two bills on the table, and I'm not taking there's elements of this in both bills. I'm just taking the language out of that one. But you've got to, I don't want the person in the example I gave earlier to be held responsible. He didn't do anything wrong. Right. And those are the people that ought to be protected. I think the language here goes toward that end. But unfortunately, you're kind of the intermediary here. You're like Moses down from on high to give us the commandments.
That's bad.
I'm saying to interpret something that we don't know. I wish we could know. But if you can find a way, I'm not saying the insurance company is your God. It's not the point. But I see the Baptist convention out there. I'm going to get in trouble for that, Tony. The point is, I'm just trying to find a way. Those people should not be in trouble. And I hope that would help limit their exposure. My point.
Thank you.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. How are you?
Good to see you.
Good to see you. And one of the questions I wanted to ask you too was just regarding, the common denominator in this when it comes to your industry and the organization or the folks that you represent here is, alcohol, correct? Mm-hmm. What's the other common denominator? It'd be vehicles, correct? So we've had, and kudos to Senator Adams, we've also had quite a bit of debate regarding the DUI laws here in the state of South Carolina. And, we're not exactly the shining stars of DUI fatalities in the country. I've heard fifth worst per capita, some pretty astounding statistics. So I guess the one thing that I, would like to see is relief for your people. And I'd also like to see relief for the families that are affected by these tragedies. I don't know if you've ever been around someone that's been involved in these, but, it's terrible for the bars, the restaurants. It's even worse for the families that have felt this pain and hurt. And so one of the things that I think it will likely happen, and because these are all conjoined, in my opinion, they overlap, the tentacles cross, is that we have to, and I believe that we will actually address the DUI laws and hopefully close that gap. Because ultimately, at the end of the day, and correct me if I'm wrong, the only way that insurance companies can make a profit, and profits aren't necessarily a bad thing, but when the claim numbers don't go down, they've got two options, right? They can either raise rates or go somewhere else to try to make a profit. Right. And so if we are able to reduce the overall amount of claims, hopefully that also, in my opinion, would have an effect on insurability. Would you agree with that?
Oh, we're very pro DUI legislation. We do believe that that's something that needs to be addressed.
Okay. Thank you, Matt.
Other questions? Let me ask one real quick, and then I'm going to go back to Senator Walker. I've asked, and you agreed that you participated, sat in, if not testified, at both House and Senate subcommittee meetings regarding this topic. Did you also sit in the 3 meetings that were held by the Insurance Review Study Committee?
Yes.
All right, and you were familiar with their January 7th, 2025 report. Perhaps that committee made up of House and Senate members, Senators Massey, Turner, Hutto, House members Caskey, Bailey, and Kirby, Lee Jedziniak, Rob Tyson, and Charlie Condon participated in that. But page 2 of that report, apparently in the last hearing on December 10th, focused on what we're talking about. And so this quandary of, do you believe anecdote or do you believe facts? And last week's exchange, Senator Massey and Senator Lee Cope, the data either does or that data doesn't. And cute line, forgive me for this going off topic, but a great podcast by Motley Fool. And they were talking about, it's a business, companies, stocks, anyway, it's a great resource. But one commenter said, you and I may lie to one another, but the numbers don't, unless the numbers are fudged. And so my point to you, either we believe anecdotes or we believe the numbers that establish that your numbers have not gone down. The restaurants and or bars, the permits that the Department of Revenue issues have not gone down. And the state is quoting the report. I didn't write this. According to, this is Perry Mathis from DOR, the state has remained steady in terms of number of active licenses. There is not an anomalous rate of suspensions due to the failure to meet the liquor liability requirement, which, again, this report, not my writing, contrasts with the anecdotal reports of mass closures of bars and restaurants due to inability to maintain coverage. So help me with the numbers or the anecdote.
So I referenced the Department of Insurance's numbers earlier. I haven't had really a chance to talk to Perry, and I was here the day he gave that. And I think I said this to Senator Ott a few minutes ago, that we do see closings, but we do see new businesses opening. So the number is fairly steady for now, but most of their renewals, or a lot of their renewals, are just coming up. Some of them are, in fact, I think, I want to say it's this week, it might have been last week, there was a ABL webinar that DOR is putting on for just this purpose, to make sure that you are in compliance, that you know everything you've got to do, that you've got to qualify. I go back to, in 2022, all I was hearing at the time was, wow, my insurance is so expensive. And then by I'd say early 24 to the middle, to last year, people were like, I can't find anybody that will write me. And so I think if we wait until we get to that far of a crisis, we've waited too long, because we know this isn't going to change overnight. No matter what you do here today or in this legislative session, it will take a year to 2 years, I think, to see substantive change in that scenario.
Well, and again, he's not the insurance expert perhaps, and we will ask Director Wise shortly, but again, Administrative ABL Division of DOR, Perry Mathis, said that 7 or 8 providers are offering liquor liability insurance in the South Carolina market.
Don't get caught in the language, though.
Let me finish the question, okay, and then you can help parse it. Again, this, in the meeting that you attended December 10th, 2024, reported in the January 7th, 2025 report. Perhaps he's misstated. Help us.
No, he's
clarify.
not misstating. I think it's just a clarification of, yes, there are some companies who will offer some alcohol coverage. It's not all the coverage that's going to apply to that mandated $1 million. And some are not carrying, as we like to call it, hard liquor. Some are just beer and wine. I mean, there are different pieces, and some will write a part of it. So you might have a carrier who will say, well, I'll give you some alcohol coverage as part of this policy, but I'm only going to cover this percentage. So then you have to try to find other carriers to combine with that.
So, and then I'll hush. I've got two ahead of you, Senator Graham, and I'll come to you afterwards. But again, pick your narrative, pick the description. Some describe this as a access and affordability to liquor liability insurance coverage. Is that, do you embrace that narrative?
We definitely have both.
All right. And so access, of course, you know what that means. We want more coverage in the market. Affordability means the ability to pay the premium.
Right.
Do you believe that either of these bills is going to do anything to lower the rate of increase of the affordability or ensure a greater access for it?
I would like to say yes, but I have no assurance of that at this point. I think we still have to make an effort to make change, even if it's steps.
And if it has been said that effectively we, and I'm paraphrasing, again, the description, we have to trust that the insurance companies are going to do right by us. Have they done right by your membership since 2017?
I'm not going to say that either, because I think they are in business, and as somebody said, it's not a bad thing to make profit. And if they've chosen, you know, I've said this: if they were all still here and all still selling and jacking up the price, I would say, oh, that's greed. They've literally left. I mean, it's not even that they're going to sell it to you at whatever price they want to offer. We just only have a few that will even sell it at any price. So that tells me there's a problem. And it's not just their greed, as some have wanted to say. My dad sold life insurance, very different. You're either alive or dead, no question. So I just would say, you know, we have seen nothing but it get worse. We have heard other states address it. We know that we are the only state. I don't think either Florida, Georgia, or North Carolina has a mandate of any kind. I know my counterpart in Alabama, when I called her about their bill, said, "Oh, we were the worst in the nation, and we had $100,000." And I went, I have $1 million mandated, you know, so I just don't know that that is the deciding factor. And I do think that we as an industry can prove that we are training and we're willing to do more training. I know you've wanted.
You've supported my efforts. Senator Massey's included server training in
Right.
his bill, so kudos for this continued effort.
But I will caution, when you start making anything mandated that we are already doing, and we know that that's happening because the insurance carriers are asking you, have you trained, that cost is also going to go up.
Finally, for me, forgive me if I lie, I'm not intending to lie on that, but in terms of your membership, surely, maybe not a member of yours, but well-circulated quote from a smart, probably good operator, effectively in the business of serving alcohol, said you'd be a fool to only have $1 million in liability coverage.
That's probably true.
And so your membership, would it be the exception than the rule that they only carried the minimum limits, or would you know?
I think that I would, and I started in this role as this became a bigger issue, but knowing my past history with the industry and my involvement, which goes all the way back, I hate to say 4 decades, the good operators are good operators, and they're covering everything liability-wise. And yes, they probably had more than $1 million, but when you mandate it, it changes the equation of what somebody can charge, and it puts it out there that you've got that, and if you put it per occurrence, that just adds that on top of it. So that's why we were, and it wasn't until about August or September last year that we got that clarification from DOR that it was aggregate. I think that's right. I think you said 20, was it 23?
Not 2003, but 2023.
Yeah. I was thinking that I looked it up in my notes and got it there. He could have clarified it for others prior to that.
Okay. Senator Graham, if you have a question, I'm sorry. No, I withdrew.
Okay. So, a couple of things. So, how many, in your association, how many restaurants do y'all represent? Is there
Counting ones that don't serve alcohol?
Sure.
Probably about 1,500.
And then a minute ago, we were talking about insurance providers for liquor liability. How many are in South Carolina that are actually providing that? So there was some discussion about different ones providing, but what's the total number of insurance providers that you're?
I don't know for sure that would cover pieces of it. I do know, just going anecdotally off, I mean, they send us their quote sheet and say, hey, this is what my broker got back, and they mark off, not going to quote it, not doing South Carolina, whatever. We generally get down to about 3 right now.
And in those 3, and obviously trying to watch some of this testimony and trying to keep up with all the discussion, one of the concerns is, for me, is, it's my understanding that the insurance companies haven't talked to anybody. And this subcommittee or last year, and this seems like this debate's been going on a long time, seems to me that they need to be at the table. And maybe I'm missing something here, but you talk about, only being 3 providers. For me, I want to know who they are. I want to know how their businesses are doing. I mean, because ultimately they're hurting small businesses. They're hurting the businesses that are in our backyard, and that's a problem, especially if they're not willing to come talk. And maybe I missed something, and maybe, somebody else can enlighten me after I stop talking. But I do think it's important that the parties that are a part of this need to be at the table, and to this point, I haven't seen them. Thank you.
Yeah, thank you, Mr. Chair. And Ms. Cohen, let me just tell you how much I appreciate not only you being here, but your candor as well as your humility. The fact that you were willing to say that there are no assurances, or you can't give any assurance that these bills will increase accessibility or bring down insurance rates. I know as far as accessibility, we have this paltry, number of, I guess, carriers in the state that are willing to issue liquor liability policies. And then, of course, there's the affordability piece, right? And so I guess my question to you would be, do you think we are putting the ladder on the right wall with tort reform? And perhaps we ought to be having discussions about perhaps insurance reform in this state, especially as it relates to the affordability.
I don't think I could speak specifically to insurance reform. I would say that we hear things that, as you're terming it, related to tort that affect our industry, and we're hearing, quote, dramshop issues that affect our industry. So
let's stay there for a second.
To address both.
So you've heard about things that relate to tort, or torts rather, that impact your industry. But how can you say that it is torts that's impacting your industry when it's the insurance companies that have made the decision to raise premiums?
Because when I hear or am given a quote by a member who says, my insurance carrier dropped me because of South Carolina's first drink law, to me, and I might be interpreting that wrong, but that sounds like part of tort.
Hence, we should be talking about insurance reform, right?
And balancing who's responsible and who's paying the bill.
Okay. And I think the proposed legislation, helps in that regard in terms of trying to ensure that the bad actors are held accountable and that the good actors aren't held accountable for the actions of the bad actors, right? But I guess for me, hearing so much from the business community about insurance being inaccessible or not being affordable, and then what seems to be the go-to position is we have to do something about our tort laws, but no one's saying anything about insurance reform when the complaint or the gripe is about skyrocketing premiums. And so for me, I would think that the discussion should be a little more balanced, maybe take a more comprehensive approach in addressing the business community's concerns, not just looking at tort reform, but perhaps looking at insurance practices, or what do we do about insurers who issue liquor liability policies, whether or not if those carriers are in fact sufficiently regulated, right?
Well, first, I just want to clarify that. I'm not speaking on behalf of any other
I know you're
industry
not.
today.
Sure.
Because I know that there are a lot of concerns. You asked me specific questions about the liquor liability, and I think it's a combined issue. And I don't know if I could tell you that, it requires insurance reform. It's simply business. We're not making money to cover our premiums, so we increase the premiums, to cover our losses, so we increase the premiums, or we're just not going to write in your state because it's not profitable.
You mentioned something as well.
Free market.
There was an example you gave, and I don't remember it to be exact, but the gist of it was, I think there was a bar owner or a restaurant owner, who was held accountable. At least his insurance company decided to pay on a claim when it was clear that the restaurant owner didn't do anything wrong. Is that something that's pretty frequent, or do you see that happening frequently?
I couldn't speak to the exact number. I think I see different pieces of it. I see settling. I see people thinking that they could defend themselves but not. And I think more often than not, I am hearing more that they are settling because it's too expensive and it's too big a risk under the current circumstances, whatever we want to say they are, to try to take it to court.
I just find that interesting, and I know,
Sad.
I know you don't speak for the insurance industry, okay? And if my questioning comes across that way, please don't take umbrage. But they're not here. But I guess I find that interesting to ask someone who's an injury lawyer, ask someone who's practiced now for nearly 20 years, and there are other lawyers who are members of this committee as well. And I think most of them will tell you that out of the 42 counties in South Carolina, most venues are not plaintiffs friendly, if you will. And oftentimes, insurance companies will make a decision to take a case to court just based off of the venue that the case has been brought. So I'm a little taken aback or surprised, if you will, to hear that insurance companies are deciding not to defend or take a case all the way to trial when it's clear that they have an insured who's done nothing wrong, and most venues in South Carolina are not friendly to injury victims. And my final question for you has to do with, I think you mentioned businesses earlier, about businesses that are closing down as a result of high premiums or what have you. Where are you seeing that around this? Is it statewide, different pockets?
We've had them in all the major areas, all the bigger. Well, I don't know as much about the small towns. I'm hearing that from some of their mayors and from some folks in the municipal association, but I know we've had them closing in Greenville, we've had them closing here in Columbia, we've had them close in Charleston. So it's not in one particular pocket or another.
And the reason I asked the question, Ms. Cohen, is because I think as you know, as far as my background, serving on Richland County Council prior to running for the Senate, and that wasn't too long ago, but I think in 2023, Richland County was in the top 3% nationally, according to the U.S. Chamber, for small businesses opening up. And in the governor's state of the state this year, he touted South Carolina's record when it came to economic development and small business. And so when I hear that we have all these businesses closing down because of the lack of tort reform or because of our dramshop laws, it sort of militates against what we hear from the U.S. Chamber, as well as what we heard from the governor in this state of the state. That's all. That's the only reason for the question. But I appreciate you being here. Yes, ma'am. Thank you.
All right, Senator Johnson.
Ms. Cohen, just
I'm doing pretty good for somebody that didn't sign up to speak, huh?
I
There are
appreciate
others in the room, be on notice. that
I'm feeling the darts in the back of my head.
You're doing great, and you're not a lawyer, you're not expected to be, but you're helping us define what your membership is telling you and helping us prove, and you prove, whether it's anecdotal or factual. And so one bad case does not perhaps create the state of the state. Senator Massey's point to you earlier about the multiple defendants in the drunk driving case, there's an ability, is there not, for an offset? You don't know that, but we know that, such that that last man at the trough, or the defendant who goes forward, doesn't pay the full freight. Now, they may pay the cost of defense, but I'm told by other smart lawyers, I may be wrong. They may be really wrong. There's an ability for an offset about what that last guy pays. You don't maybe know that, but perhaps we'll hear a different answer to that.
I will defer to Senator Massey.
The contribution law applies to defendants. It uses the same word.
But there's a contribution among joint tortfeasors that
And the-
allows the same co-defendants to go against the other, does it not? That such that if they, and I've been involved in a case, just finished a horrifically bad case where that is underway right now. And there's an action going against the last defendant who killed somebody that has got great merit, such that they will recover and have the means to recover
Against the last defendant.
against a settling defendant.
Well, Senator, I would tell you if your interpretation of it is the way that it worked in reality, I don't think this would be an issue for the industry.
It's underway in a courtroom in this state right now, and that ain't anecdotal. There's a caption where that case is being litigated right now. Ms. Cohen, again, we're going to move on. I apologize, but you're not a lawyer, and I appreciate your deferring to folks and to the subcommittee chair. Real quick, let me tack back to you.
Ms. Cohen, I want to go back to the case you talked about. Guy's drunk, they cut him off, gets in an Uber, goes home, gets in a car, kills somebody, as I recall. I think I've been told about this case.
Yeah.
Didn't he go home, drink more? I think or went to a store and bought more, and then he went out.
Yeah,
and killed
I don't know
somebody?
the specifics of it. I just know it has been, it was involving someone in our
As I recall,
industry.
and this story was told to me about a year ago, so my memory may not be it, but it was, he drank, was cut off, sent home, got home, he had gone to the bar on his motorcycle, got home, got in his car, stopped somewhere, bought more beer, because he wanted to go back to the bar to pick up his motorcycle, which didn't make a whole lot of sense, and kill somebody on the way. And I only bring this up for this reason. The bill talks about that the sale of alcohol has to be the proximate cause, because I want to fix your problem. So I read this to say, where it says licensee knowingly sells, serves, and the sale of the alcohol was the proximate cause. That the fact that he did things along the way ends that proximate cause, and therefore the bar has zero liability. And if it's not written that way, I do want us to, because I want to make sure that we have a bill that does stop your scenario. So I want to kind of get to that end.
I think that kind of clarification in the language is definitely something that could be helpful. I know of one particular business in the upstate that was so concerned about a scenario like you just mentioned that they were actually making people take a breathalyzer test when they left the bar. I don't think we want to get to that in South Carolina. I think if you want to talk about what I saw that.
I'm with you.
Yeah, I mean, it's crazy.
I'd hate for a teetotaler to take that exam and fail it.
Yeah, well, that would be concerning. I just think your point is well taken, that it needs to be, a a reasonable person would have determined that this person was either already overserved or would become, or, once they leave, if they were not impaired reasonably, visibly, that,
The point is that you're going to cut them off.
Yeah.
When they're visibly
Right.
impaired, you're going to cut them off, and that's going to end your liability. per
Right.
se. So I'm trying to figure out, when I leave, I go home somehow. I get, somebody else drives me home. Doesn't matter how I got there. And then I go out and I kill someone. What is the type of language that you're looking for to stop that liability? If that's even something that can be done. I mean, I don't.
I'm not sure, because you don't know what they
Senator
have in their
Mansfield may have
car.
that answer already.
Mr. Chairman, the problem with, and I appreciate you trying to get to the crux of the issue. The problem there, though, is that every time that is a jury question, right? And as she said earlier, the carriers are afraid to go to trial. Now, I agree to some extent with the senator from Richland. I mean, I think they ought to try more cases. But in that situation, if you put that case in front of a jury and the only defendant is that bar, and the jury hears what the catastrophic injuries were to this person, they're going to be overwhelmingly sympathetic to that. They are not going to say no to that person more often than not. And if they are the only defendant, they're going to get, even if you change that language, the issue is the fact that they can be on the hook for the whole thing. And that is what's driving the risk assessment from the carriers, right? I mean, I understand the questions about why aren't they at the table. I mean, this is the same attacks from opponents in Alabama or Florida or Georgia, right? But an insurance company isn't going to be able to tell you whether this is going to lower their rates or not, because they've got to see how the laws affect their risk. Then if this has an impact of lowering the payouts, that affects their risk assessment, right? And then that's going to affect the rates. But they can't tell you that now. They're not going to come up here and stand in front of you to have to answer. They can't tell you that. But I think, Senator, to you, sure, they've got to see what happens so they can factor that into their risk assessment. If they can't assess their risk, they can't tell you what the rates are going to be. And they can't assess the risk until they see what the impact is from the law.
Senator from Edgefield, isn't that the proverbial chicken and egg, which came from? I mean, when can they? At what point do they are making risk? All insurance is an assessment of risk.
Well,
right?
It is
and
what
whose
she
risk
said.
It should be.
It is what she said earlier, that you're starting to see a couple years later some effects of the insurance DOR's interpretation. What you just saw last week, Governor DeSantis in Florida announcing rate reductions 3 years after the legislation was implemented. They've got to see how these things play out, and that affects their assessment of what their risk is. If it lowers their payouts, if it makes it more certain as to what their risk is, then you'll see the effect of that. And I think specifically, though, to what you were talking about, if you leave the joint liability exposure and do those things that you're talking about, it's not gonna have any impact on the
You would have to remove the alcohol part of Section F, no doubt about
But
that. And I'm
Section
not
F
gonna-
isn't-
I know
but that's
you have
inadequate.
more things, but if you removed that, and just saying
You
as an
still got
example.
the provision that says that the 50% threshold applies only to defendants. In her situation, you've only got one defendant, right? So that defendant, if he's 1% responsible for the whole thing, he's 100% responsible in the trial.
But Mr. Chairman, could I ask a clarifying
How could
question on that?
I guess it goes back to whether proximate cause is a jury question. The reasonableness is a jury question. And this entire alcohol section is based on a reasonable man standard of were you visibly intoxicated.
But it's fine, even in her situation, if you allow that bar to tell the jury about everybody else that contributed to this, and then let the jury say, in the grand scheme of things, how much was this bar really responsible? right? Because then what's going to happen is the jury's going to say, in the grand scheme of things, 5%. But otherwise, the way that it is now, if they're 5%, they're 100%. If they're the only defendant that's there.
Mr. Chairman.
Real quick editorial comment, and there's this Wall Street Journal opinion or editorial, I guess. What was it? It's last Monday, that touted the benefit of those tort reform efforts in Florida, and in contrast to California. And we know what's happened in one state. And as reported and as repeated today, there's some indication that in the state of Florida, that the rapid rates of increases, or let me not say that the rates are going to go down, ignoring the fact that over the intervening 3 years, tremendous rate increases to all property classes. Again, we're not going to debate this now. I'll talk about it on the floor, but that was a property and casualty comparison, apple to apple. Mentioned in that also was glass damage to cars, but more to the point of what has been discovered. Maybe it's true, maybe it's not. Some chicanery going on among the insurance industry in Florida, such that had the General Assembly known, they would not likely have done what they did with the rates of profits paid out to their effectively TPAs, their affiliates. We'll flesh all this out later on. Ms. Cohen, you have been most kind and patient to hang around here. Again, whether it's a contribution or set-off between joint tortfeasors, you have nodded appropriately like you know what we're talking about. You're here for relief, and we hope we can give it to you, and we hope we can give it to the good actors and not penalize them for being good actors and reward the bad.
Thank you. That's all we ask.
And I'm sorry, Senator Kimball, and then there were two more, one more, Senator Stubbs. But
Thank you, Mr. Before we got too far off that, I don't know which one maybe wants to answer, Senator from York, Senator from Edgefield, but I wanted to ask a clarifying question for those of us that don't practice in this sphere. But to the language, Senator from York, that you mentioned a moment ago, we're talking about essentially this debate on whether we go to jury trials. And I agree that some of these cases need to be tried more often, Senator from Edgefield. I think they do need to go.
Real quick interruption. Two that I know of, one in Horry, defense verdict. All those things that the Senator Massey said, 12 jurors from Horry County said no. What? Horrific result, oddly, shocking, but 12 jurors said no.
And that's good, but isn't it true? And I mean, I'm honestly asking. I think this is true, but I don't practice, obviously. So, if you have this kind of language in statute, if we enacted this, and I understand what you're saying, if you have a jury that's hearing about horrific injuries and they're sympathetic, can't you basically, if they take some of these to trial, can't you file a motion for summary judgment on some of this and basically say, look, they don't meet the threshold and have the case dismissed anyways? I mean, can't you have a motion for summary adjudication before it ever goes to trial?
You can do that. If there's something that is a jury question, you're not going to get summary judgment on it. On, like he was talking about, with reasonableness.
But if we enact this language, though, and it doesn't meet the threshold, can't we get it kicked out before it ever goes to that point?
Most of the time, those things are jury questions. And I'll also tell you that in state court is very different from federal court in this case. State court judges, circuit judges are not they don't grant summary judgment a whole lot. They will usually let things go to juries. In federal court system, those judges will grant summary judgment more often, but you don't see that a whole lot in circuit court here, especially on a like what you're talking about with if the word is reasonableness and things like that. That's an almost always.
They're still going to want to throw it to the jury?
Yeah.
All right, thank you.
Well,
And they're judges that we all elect, we vet, we question. We get to ask them these questions. Are they abiding the law? Perhaps we need to change the law, and that's kind of as you say, a policy decision to not let the judges have the discretion that these current laws afford them. Senator Stubbs, and then we're going to let Ms. Cohen go unless.
Thank you, I don't think this will. So speaking of policy, do y'all believe that we should punish wrongdoers?
Oh, absolutely.
Thank you.
You have kids?
I have a 6-year-old and a 10-year-old.
So if the 6-year-old runs through the house and breaks a vase, do you punish the 10-year-old and take it out of their allowance because they have more?
No, ma'am.
And if you do, does that stop the 6-year-old from running in the house? I mean, it's kind of,
I'm gonna give you the
Whether
real,
the 10-year-old is drinking or not.
but realistically,
that grape juice, that'll get you every time.
it really depends on what Mama says.
Yeah.
That's the way
I mean,
it goes.
it's really, that sound, I wasn't trying to be flip. I mean, it really is that simple. We are not against a victim being compensated by any stretch, but you can't create a second victim by making somebody who's not responsible have the burden of the payout. I mean, it's not fair.
No, and I do totally agree with that. And the reason that I asked that, right, is that from a public policy perspective, it seems that we should encourage good behavior and discourage or punish bad behavior. And that's
Absolutely.
just what I was asking. Thank you.
And not
Senator
for-
Tedder, yeah.
No, I don't have any. This is so she can, if nobody else has questions.
Well,
we can
and I do want to give you the final say. You've effectively done it with a 6 and a 10-year-old. That succinctly says what you want to do.
Right.
But you've described how the current law is hurting. Again, either factually, anecdotally, if there's one bad case, that becomes the norm. We get that. Perception is reality, right? But my question to you on the flip side, what is it that you think is going to help? And how will this help your membership?
I think if it's applied correctly, it will help the good actors. If you take action that's both, again, whether it's with our legal system, whether it's with our insurers, whether it's actually with the dram shop. I mean, I think there's probably a combination of all three that needs to be talked about. But if something's not done, then I think what we've seen is that escalation that you guys are saying, is not showing up in the numbers yet. I promise you, I'm not making up the phone calls and the emails that we get from folks who are going, I can't do this anymore, and I'm going to end up going out of business if they haven't already. That's my concern. And I don't think that that's anybody in this room's intent, but that's the reality of what's happening.
Department of Insurance, 1. Department of Revenue, Enforcement, 2, correct? Mm-hmm. And the laws that this General Assembly passes, and then the enforcement of those laws by civil or criminal executive power, correct? You need all of those branches working co-equally, correct?
In our industry's case, yes.
Okay. MAD and the folks that have been involved with MAD, you've heard them testify, they're here. I would urge another conversation out of this room with those fine folks, and
Happy to.
And I thank you very much for being at the right place at the right time for
I
us.
was trying to hide back there.
Can't hide. All right, Director of Insurance is here. Director Wise, come on up if you will. And I appreciate your jockeying. Oh, I'm sorry, yeah. Come on up, but we're going to.
Yeah. No, I just wanted, Mr. Chair, I just wanted to, before we move forward, just to clarify something. So the fact that it sounds like we are not giving our jurors enough credit. And so, because I wanted to go back to the scenario where the person drinks at a bar, has one drink at a bar, goes home, buys liquor, gets plastered, goes back out. I mean, those facts presented to a jury. I mean, I believe our juries are smarter than what we're giving them. And in the instance where the senator from Edgefield, I think your argument was that if the bar is the only defendant remaining, they will always be 100% liable. And that's not the case, because with the Horry County case, I had a buddy that tried a case about a year ago. 23-year-old, multiple drinks at a bar, bad injuries, and there was a trial where the jury decided that the bar was not at fault because that particular defense attorney, they argued the empty chair. They argued it was the drunk driver's fault. And so because of the fact scenario that whatever they presented, there are instances where the jury gets it right. And I think when they hear all of that, when you got somebody getting one beer at a restaurant and then going to buy a bottle of liquor, and you can show that, I mean, I just don't see how a jury would. So this is not happening all the time, and so explain if it's always 100% liable, if the bar or restaurant is the defendant, the only defendant left, then how are cases like that being given defense verdicts in Horry County where they were the only one on the phone?
Well, and just if I could, just very quickly, I would, and I'll do it very quickly, but I'd say, look, as I said before, if a jury believes that restaurant, whether it be in Horry or in your situation, was 5% responsible, they're going to be 100% responsible because they're the only defendant. The situation that you've identified is one in which a jury determined they were not responsible at all. Well, if it's 0%, then it's 0%. But the problem is that like you've got some folks here who, some insurers, and I wish they would do this more often, but they rolled the dice, right? Because they thought they had a good argument that there's no responsibility here whatsoever, and they got some juries to agree with them, apparently. But I will tell you, and I think Ms. Cohen just told you this, that's not what's happening normally. What's happening normally is there's some concern there could be a little bit of liability, and if there's a little bit, it's all of it, and they can't take the risk, so they end up paying out more than what they ought to pay out, which has the ultimate effect of driving up the premiums.
But to that point, I mean, that is a calculated risk among adults in the room, actuaries, weighing risk, that we're not tilting by fixing the law just to help that calculus become advantage to one group over the other. Whatever we do, whether it's civil liability, whether it's criminal, again, the balance of adults in the room making conscious, sober decisions to or not to try a case, and the risk allocation that you make when you're representing your client, saying roll or not, I mean, equally.
Yeah, but the question, I mean, right now the rules not only allow, but in many cases require the 10-year-old to pay for the 6-year-old's conduct. Right? I mean, they do.
If the 10-year-old, in this context of a liquor liability or a Department of Revenue licensed bar owner, on premise, purveyor of this wonderful commodity, but a dangerous commodity, overserve somebody, and the point from drinking it to the point of impact is less than a mile, those are bad facts.
They ought to be hammered.
And so if a jury decides to hammer them, isn't justice served?
Sure, they ought to, in that situation, absolutely they ought. Now, I still think they ought to be responsible for their portion for what they cause. Because you've also got a guy who gets in the car and drives when he shouldn't be driving, right? That person should get hammered as well. Nobody that I've heard from is saying that victim, and it is a victim who almost certainly did nothing wrong, there's nobody saying that person shouldn't be compensated.
Well, and
the question is, who should? I mean, right now you've got a situation that would allow, even in your example, would allow the bar to be 100% responsible, and there's no way that's possible.
if that bar, and this is a factual, not an anecdotal example, I can give you a site. If that bar serves somebody with credit card receipts showing 12 drinks, they claim that they call a cab, they call and, they call a cab and say, I've got a ride for you. They claim that the husband came and picked up the lady and took her home. They claim that. That person drove 0.3 of a mile. I don't think it's that, but it is within eyeshot of the point of impact. Hits and injures, two-car collision, and litigation ensues, and there's testimony from the bar that we called, we watched the husband come. He came and picked her up. Discovery reveals that that husband is at a VA medical appointment. He's not there. So in that case, with not $1 million coverage in place proceeding, what did they decide to do? They decided to pay the claim. So is the person who sat and drank, and this is the debate, guys, and forgive me for us talking about it, but it'll be on the floor later.
But it's instructive. I mean, this gets
to the point of holding responsible the person who happily laps over their credit card and gets as many drinks as they can to the benefit of the perhaps server only, perhaps the managers didn't pay attention. Is it the victim's fault that the poor little insured was victimized by the bar, who made a little bit more money on them than they should have? And ultimately, it should be their responsibility, drunk driver, because how did we know that you got drunk after 12 drinks that we sold you and we could prove to you?
I don't know that anybody's going to question whether that insurance company for that bar should have been paying out.
My point is, and again, perhaps I'm missing the exact intent of this, but the point of this is that to say that it is the victim's responsibility if they only have, the at-fault driver only has a minimum limits policy, you're saying in that instance that the bar should always be held accountable, correct? Or not?
In the facts that you've outlined, I think the bar should always be held responsible in those facts.
And those are questions of fact that juries either will get to decide, or if the smart bean counters in the room.
That was never going to a jury.
But maybe they should have tried it, because maybe that claim that, hey, it's the drunk driver's responsibility, maybe a jury would buy that.
Yeah, but even if, I mean, the facts that you've outlined with in the over-serving and you got the credit card receipts, you got them lying about calling the cab and all those things. I mean, that's a situation where you pay out the coverage. That's not really the situation that we've been talking about here, I don't think. That's not the intent anyway.
So that if we change the law that it says, again, as we'll debate this too, the exact fix, if you prove that a person at the time that they left that bar was knowingly, visibly intoxicated, we're changing that. But if they blew a 22 an hour later, or they blew whatever the number, again, the effect of that, or a 15, retrograde proof of intoxication. I'm going to move on from this. But
this is a good debate. I mean, this gets to...
Isn't the dialing back, even in that horrific example, to say it's not 12 drinks, but it's 8, it's 6, it's 5,
I don't know that
3.
it matters the amount of the drinks as it gets to, I mean, and this is something that the senator from York and I, and we've talked about this a good bit in the subcommittee too, and I think he even touched on it today about what should that language be? You know, because we had conversation about should it be visibly intoxicated? Should it be something different? What does that mean? I don't think it matters on the number of drinks as it is to, is the person intoxicated? Right? I mean, that number of drinks may be different for you than it is for me. Or for other people, right? But look, I don't want, and I don't think anybody, I mean, nobody wants bars or restaurants over-serving people who are intoxicated. And so there should be some liability to that effect. The question is, you know, you get the very real situations that Ms. Cohen talked about. I mean, those things are happening, and those things are factored into the risk assessments, which then affect access and affordability that you've talked to. And that's my assertion.
Senator Cash. And Director Wise, while we're waiting, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Continue to be at ease. Senator Cash.
So in trying to pick up the gist of some of this argument, Senator from Edgefield, it seems like we talked about a situation where maybe a bar, restaurant served somebody one drink, and then they went home, and then later went out and got some more alcohol and